three magnificent interventions. First, Francesco Vigano presented us the public relations policy of the Constitutional Court of Italy, which proposes a counter-narrative to the media and to the general public in order to clarify the meaning of the main cases discussed by the Constitutional Court. Second, Andras Shaiu went through the challenges to irremovability when we discuss the restoration of the rule of law in some countries. And then finally, Judge Anka Eilers presented us the work of the CCJE and specifically the soft law standards that were enshrined in the case law of the European Court. This dialogue between the court and the CCJE was in fact promoted by Andras Shaiu as president in many judgments where we tried to accommodate these soft law standards and to disseminate this principle set by the CCJE. Now I would like to give the floor to our audience, and if there are any questions that should be addressed to the panel, please come forward. And yes, please. We still have 3 to 5 minutes.
Yeah, okay. Well, thank you very much. Well, I come from Spain. My name is Mariano López Molina, and I'm a representative of the Judicial Association Juezas y Jueces para la Democracia. So I would like to ask you a question, because right now, for instance, in Spain, we have a problem with the renovation of the mandate of the General Council of the Judiciary, which has been operating for more than 3 years with an expired mandate. So right now, but the problem in Spain is that, especially maybe the Council of Europe says that the National Council of the Judiciary should be elected. I mean, right now in Spain, there are 20 members sitting in that council, and 12 of them, according to the Constitution, well, 12 of them have to be appointed within the judiciary itself. So right now is that judicial associations propose 36 candidates, and then it's the Congress which appoints within those 36 candidates. But my question is, don't you think that within the, I mean, if judges in the General Council should be elected by their peers, by their colleagues, don't you think that, I mean, within the judicial associations, there are always political tendencies, very clear political tendencies. And those political tendencies and currents are going to be reflected in that General Council of the Judiciary with no control whatsoever by the Parliament, which represents national sovereignty. So, I mean, maybe I think it's not against of course, the European Convention of Human Rights, a situation where some of the candidates proposed by the judicial associations are examined in the Congress, and then it's the Congress who is going to appoint, if there's a political agreement, those members from the judiciary who are going to sit in the General Council of the Judiciary. Because it's like the intention, some of the judicial associations, the majority of them in Spain say they think that the current General Council is politicized. But as I said before, there are always political tendencies. And actually, for instance, in Spain, the majority of the colleagues are, I mean, there is a clear political tendency. Most of them are conservative. So that's my question. There are always going to be a political tendency. Yeah. How to control that? Thank you.
Thank you. Maybe we could take 2 more questions, please.
I'm sorry. I know it's a bit already a bit late, but maybe you can postpone 15 minutes the start of the next session. But I would like to ask a question because it's not mine. It's like yesterday. It's a Turkish judge in exile who is watching online this session, and he asked me to ask a question to the panel regarding this recent decision on the Turkish judges. Basically, trying to sum up this and to be very short, basically the European Court of Human Rights, in other words, said there's a big load of cases coming in. We are not able internally to analyze all the aspects involving these cases, so we will just analyze one of the points of the cases. And at the end, they gave a 5,000 euro compensation. And what our Turkish colleague says is that it's not a privilege of the court to analyze the cases. It's also a duty of the court to analyze the cases. And isn't the court, with this decision, giving an image to all the countries wanting to breach the rule of law that it's better to do it on a massive scale than to do it on one or two cases? Because if you infringe the rule of law in the appointment of 1,000 judges, the European Court will not have the capacity of analyzing it. So it's better to do it in 1,000 judges than to do it in one or two. That's the question that he's asking. Thank you.
Third question. Yes, please.
My name is Monika from Skopek. I'm representing Justicja in Medal. I'm from Poland. And I would like to say that what Professor Shire said, this is the most challenging issue we face in the future, definitely, what to do with these judges. And it also somehow is referring to the question Orhan asked our Turkish friend. And when you look at Poland, Minister of Justice waited 2 years for new appointments, and he frozen the whole procedure, waiting for new judicial council to be established. So then we had like thousands of vacancies, and then new judicial council produced like machine, new appointments and new judges. And we have actually the same problem here in Poland. But I was wondering, because you said that, that there is this Icelandic test, and when you look at the situation in Poland, these newly appointed judges, there was no violation of domestic law, but actually it's secondary law, because when you look at Polish constitution, this law contradicts Polish constitution. So when you go into the detail, it's actually, there is violation. And I was wondering to what extent a European Court of Human Rights may verify whether there was violation of constitution of the member state regarding this secondary law. Thank you.
Thank you so much. So we have three questions. The first, if I understood correctly, was directed to me, is related to the issue of the composition of the High Judicial Council in Spain. I had the pleasure of being invited by the Spanish Supreme Court to Madrid to address precisely this issue. What I said at that time in Madrid was that I have my concerns with the situation in Spain. In fact, the fact that there is a majority of judges, according to the European Court of Human Rights and the Council of Europe standards, the fact that there is a majority of judges in the High Judicial Council does not suffice to guarantee the impartiality and independence of this body if the majority is elected by Congress. This is the big problem. The big picture here is that we have Congress blocking the renovation of the composition because they don't agree, they don't find a middle way, they don't find a political agreement to renovate the members of this body. And this is the result, the consequence of this choice, this political choice. And of course, this involves a constitutional choice. It's up to the legislator to go on, carry on with this or not, or to change. But if the situation remains like this, the only people that are really hurt are the judges. They of course cannot rely on a high judicial council that has not been renovated and is composed by people with expired mandates. And of course, at the end of the day, the problem is of the entire Spanish society, which is an extremely sensitive body for the judiciary in such a state. So the situation, I agree with you, is worrying, is very worrying. With the second question, I think it was addressed to Andrașayu. It's about the situation with this most recent case of the Turkish judges. Please, Andras.
So thanks for the question. This is the Turan case, which was decided a couple of weeks ago. Now the main problem is that these about 500 Turkish judges claimed not only that they were arrested in violation of the law in force, which was the concern of the court, but they were arrested without any reasonable cause for detention. And that has very important consequences if the finding is that, yes, there was no basis, that the detention is arbitrary. And that is the issue the court did not consider. Now, I criticize the court often enough. I am second to Paolo in a number of dissenting opinions. Okay, leave this competition aside. But I decided never to criticize the court after I left. So I continue to criticize those cases I participated in. But once I'm out, I'm out. So the only thing I can say about this, the literature is already saying that this is dereliction of the duty to decide cases. I'm not taking a position on that. But I would like to say that there is probably a way out of this, which the court so far has not considered, namely to say that in these kind of situations there is a presumption that they were arrested without proper cause, and you reverse the burden of proof. And then you solve 500 cases with one stroke. The burden of proof is on the government in this situation, and you can pass a default judgment except if the government can prove the opposite. So far, that didn't happen. So I'm not criticizing the court. I'm only saying that there is a way out of this, which would solve the capacity problem that is that the court is confronting right now in the Turkish cases.
Francisco, probably.
Just a word about the composition of the High Council of the Judiciary as the Italian situation is concerned, for example, because I didn't explain in detail, but the Italian Constitution provides that 2/3 of the members of the High Council of Judiciary are elected by peers. So exactly what you meant with your question, so not elected by Parliament, by their peers. Of course, there is a big ongoing discussion in Italy just in these days. I've just read about news about proposals of changing this law about the elections of the judges, members of the High Council of Judiciary. The impression is that the current electoral system gives too much weight to the different judges' associations, which then will play a crucial role in the appointment of judges in senior positions, etc., etc. And when I say judges, I intend both judges and prosecutors, because in Italy they are part, they are subjected to the same constitutional guarantees. So the electoral law will probably be changed, but the composition of the court cannot be changed unless the constitution itself is changed. I don't know, but probably we're perfectly aware of that, but just...
I think that we have answered more or less all the questions. The third question was related to the second one. So I think we can now make a break for 5 minutes, 10 minutes, just to not to delay too much the next panel. Thank you so much.